My lord, page 19 is the impugn order, annexure 2. Here, my lord, the learned trial court at 1 p.m. have closed the cross-examination of PW5 dispense, my lord, under section 3092 C, small c of CRPC, and one of the witnesses was sent back with a and he was called again, and cost was imposed 2,000 cost, my lord.
Page
Now, my
number,
lord,
page number
page 19.
is the impugn order.
Impugn order. Now, my lord, this impugn order on the law point itself, my lord, it goes because 3092, which is not operative as on date, cannot be invoked. It could have been under any section of the BNSS. 309, my lord, this observation has to come. We are coming to many cases are there. FIRs are being registered under IPC. Proceedings are being carried out under the CRPC. My lord, these acts are not there. We have to understand that now. Any law has to be imposed in letter and spirit. When these sections are not there as on date, now, my lord, they are using these sections, my lord. A direction should go, my lord, to all the learned trial courts below, my lord, that they stop using this CRPC and all. Very well, my lord, we understand. This court can understand this section in relation to the section in the BNSS very well. I am not on that, but lordship, a direction may kindly go, my lord. We are facing lots of problem in the learned trial court, my lord.
There is a judgment of this court as to in which cases division bench judgment, which cases the provisions of BNSS would be applicable, in which cases CRPC. From when?
But this
You have that judgment.
Yes, my lord, the judgment is there, my lord.
You have the copy of that judgment. We will, this has not caused any substantial injustice.
Substantial, my lord. Every time we come up, my lord, when we have to make arguments, my lord, and judgment is also there of division bench. So, my lord, if there is a direction from this court and that judgment is circulated to all the learned court below to follow that judgment of the division bench, because, my lord, this order was passed on 17/9/2025.
Yes, that we will do so.
My lord. And my lord, kindly see, my lord, at 1 p.m., my lord.
Now, you are aggrieved with what? 2,000 cost.
1,000 cost also, my lord, that is
that you have to pay.
Because my debt should not have been, my lord. At 1 p.m. imposing cost on the parties, at 1 p.m. dispensing with the cross-examination of the witnesses, my lord, bar and bench, my lord, we work in a coordination, my lord. Sometimes it may happen, my lord, 1 p.m. if the learned trial court start dispensing with the witnesses, starts imposing cost, my lord, at the first half itself, my lord. And my lord, in the learned trial court, my lord, in many courts, my lord, cross-examinations are taken up in the second half.
No, but there is no illegality otherwise, apart from quoting wrong section.
It is not there, my lord. For that, as with regard to this section, my only prayer is, my lord, the order may be circulated to all the learned trial court below, that they will not use the wrong act now.
You give that.
I'll give, my lord. I'll give, my lord, during the course of the day only. I'll give, my lord.
Then we'll fix it in the next week only.
I'll bring the judgment.
Okay.
Or, my lord, may keep after some time. I'll just get it.
Not
at 2, my lord.
Not at 2.
At 3.
We'll fix it on. When is the next date fix?
Today was the date, my lord.
Then on Tuesday we'll fix it. You bring that judgment.
My lord.
Otherwise, my lord, only his grievance is that PW5 was not allowed to cross-examine and dispense it. Let him, my lord, cross-examine. Otherwise,
you're also agreed with that.
My lord, I am agreed, my lord. One PW has been dispensed with. I am agreed with that, my lord. One PW, my lord, cost have been imposed, my lord, 2,000. I agree with that, my lord. And, my lord, I also want that a circulation has to be made to all the learned trial courts below. That
no, what is your main grievance?
Yes, my lord.
My lord, my 3 grievances, my lord. I have.
Which one is the prime grievance?
Prime grievance, all are, my lord, 2 are prime, my lord. 1 is directly, lordship may direct. 2 prime, my lord. PW5, my lord, dispense with, I have to cross-examine. PW4, 2,000 cost has been imposed. This is very unnecessary, my lord. At 1 p.m. imposing cost is, my lord, that has to go, my lord. This has
No,
to go.
that power has to be there with the court.
Yes,
Otherwise,
But my lord, at 1 PM, my lord. Had it been 3 PM, 3:34, we would have
No,
understood the first half, my lord. First, we learned trial courts, my lord. Start calling the advocates, my lord. 1 PM cannot be a time, my lord. Otherwise, my lord, after 1 PM, in every case, there will be cost, my lord. We were ready to cross-examine. We have not filed any application before the court that we will not conduct the cross-examination today. My lord, at 1
Then
PM imposing
at
cost, my
what time cross-examination should be done?
my lord.
It should be, as per your submission, as per the convenience of the councils.
Councils and court, my lord. My lord, here, my lord, what happened, my lord? The court, my lord, imposing cost at 1 PM, my lord.
Okay. We'll issue notice and examine these questions. Mr. F. Hussain,
F. Khan, my lord.
sorry, F. Khan, learned counsel for the petitioner. Also had Mr. P. Bhattakur, learned additional public prosecutor. This application under section 528 of BNSS has been filed by the petitioner impugning the order dated 17/9/2025 passed by the Court of London Special Judge Assam in special case number 15/2023, whereby a cost of rupees 2,000 was imposed on the petitioner for deferring the cross-examination of PW4, whereas the cross-examination of PW5 was dispensed with. The learned counsel for the petitioner has further submits that the said order was passed by the trial court under section 309 within bracket 2 within bracket C of the CRPC, in spite of the fact that the Code of Criminal Procedure 1973 has already been repealed and no longer in force. Stop. The contentions raised by the petitioners need to be examined. Issue notice to the notice. He can receive notice. The PP.
yes, ma'am.
Service complete only.
The as learned public prosecutor is representing the respondents. No formal notice need to be issued to the respondents. We don't require records.
Yes, ma'am. Records not.
Learned counsel for the petitioner submits that he may be granted some time to place on record a judgment of the division bench of this court, which is very relevant for consideration of the instant criminal petition. The time is allowed. Let this matter be listed at the due. 18th of November. 18 November.
The interim, my lord, the proceedings in the land court below may be stayed, my lord.
No, why proceeding?
Then, my lord, in the meantime, my lord, the further cross-examination of the PW4 may be stayed, my lord.
When is the next date fixed?
Today was the date, next
My
date
lord,
we will get.
Only for that purpose, selling that order, my lord, he is praying for stay of the proceeding. That is
No.
the main purpose, my lord, of filing this criminal.
No. As you like a Koran, Lord, see, before the special judge, my lord, we have so many cases.
When is, before the next date is how much time the court is taking for giving next date? How much
Around
interval?
15 to 25 days.
We'll fix this before that date,
Lord,
so
we
that
fix it
no-
for next Tuesday then.
next Tuesday. 18th.
Grateful.